I am looking at that case. The first thing I would let you know is, do you know what the Grand Rapids GH and MR company is?
A railroad.
Right, it's a railroad. So this is a case from 1922, 103 years ago-ish. Others, you're not the first and probably not the last to make that argument. I have ruled before, and I would rule again. Yeah. The idea behind the thought that it's unconstitutional to require somebody to have a license plate on their car or to have insurance or something like that is an unconstitutional violation of the right to travel is simply not true. The Court of Appeal, the Michigan.
Yeah, that's not what I see the law says. That's why.
I understand we may disagree, but frankly, the court interprets the law, and that's why I'm here. So I'm going to deny your motion to dismiss. Do you still wish to have a hearing on the case, or are you willing to admit?
Right here, the judge shuts down a very familiar courtroom argument before it gains momentum. The defendant is relying on a century-old case involving railroads to argue that modern vehicle regulations are unconstitutional. The judge immediately reframes the issue. This court is not debating theory, philosophy, or historical abstraction. It's applying current Michigan law. By pointing out that the cited case involved railroads, not personal vehicles, the judge signals that precedent only matters when it actually fits the facts. This moment establishes authority early. The court isn't dismissive, but it's firm. The rules governing cars on public roads in 2025 are not governed by rail easement disputes from 1922, no matter how confidently they're cited.
Okay.
All right, good afternoon. We will begin in case 25M001076. It's entitled The People of the City of Marshall versus Leonard Jr. Cousineau. Is that your name, sir?
Cousineau.
Leonard
Jr. Cousineau.
Yeah, I keep mispronouncing it. I apologize. I forgot that I needed to broadcast this on YouTube, but we had gone through what the citation alleges, which is an expired plate, and that we're going to be you're scheduled for a hearing today. When I asked whether you wish to admit or deny, you indicated you initially wanted to deny responsibility because essentially you had a motion to dismiss. Is that correct?
Yes, I had no motion to dismiss.
And this motion was your first statement to the court was that you indicated the Michigan Motor Vehicle Code was not, at least this violation was not applicable to you because you weren't driving in a commercial sense. Is that correct?
Yes, and I'd like to ask the officer if I was hauling anybody or unloading or loading anything in my car.
Well, I will ask
that was,
the officer.
Yeah, commercial.
Officer Dickinson, was there anyone else in the vehicle?
There was not.
Okay, and was well, Mr. Cousineau.
Cousineau, you got it.
I will get it right one of these times, and I'll keep getting it wrong.
Yeah.
I mean no disrespect. Okay, so I think that the officer would grant that you were not driving for commercial profit in any way.
Yes.
At least that's my understanding. Is that correct, Officer Dickinson?
Affirm.
Okay. So go ahead with your motion, I suppose, sir.
I motion to have it dismissed.
Well, on the basis just that the Michigan
on why?
Code.
Okay.
Yeah.
Yes. Hold on. The enhancement caused by the commercial MVC covered by the traffic law enforcement education. Yes or no? And then the Michigan Vehicle Code Act 300 of 1949. An act provides the registration, titling, sale, transfer, and regulations of certain vehicle operations upon the public highways of this state. So the Officers Act clearly states that only certain vehicles are liable to the Michigan Motor Vehicle Code. Do you know the vehicles are liable to be regulated? Answer yes or no.
All vehicles. Well, it seems like you're reading from a questionnaire, and it's
I'm reading from.
So the idea is, here's what I can tell you. Here's what I can tell you about the law. Okay.
Yeah, it's about the law.
Michigan Compiled Law 257.255, which is part of Public Act, well, the Michigan Motor Vehicle Code. Michigan 1949 Public Act 300 applies to it applies to any motor vehicle being operated on a highway or other place open to the public, whether it's for commercial purposes, for entertainment, for to reach a destination for any purpose. If it's a motor vehicle and it's operated on the highways, Michigan Compiled Law 257-255 does apply. And the Michigan law does require that all motor vehicles, no matter what their purpose is, well,
it doesn't. Michigan's compiled law, the Supreme Court ruled not against that.
What case was that, sir?
This is where the core misconception takes center stage. The defendant believes that traffic laws only apply when someone is engaged in commercial activity. The court, however, is focused on a much simpler legal question. Was a motor vehicle being operated on a public roadway? Commercial intent isn't required for regulation. This exchange is important because it shows how legal myths spread online collide with real statutory language in court. The judge even confirms the defendant was not driving commercially, and it still doesn't help his argument. That confirmation actually weakens his position because it removes the last factual hook he hoped to rely on.
Hold on. Let me get it here. Okay, quoting from Grand Rapids, GH and MYRY Company versus Stevens, ETAL 219 Michigan 332 1922 at 337.
Okay, what does it say at 337 there? On page 337, what does the Michigan Supreme Court say?
It says 337, a highway is a public way for the use of public and general passage and traffic without distinction. Star versus C&A Railroad Company, 4 ZAP 597. The restrictions upon the use of only such as are calculated to secure to the general public the latest practical benefit from the enjoyment of the easement, and the inconvenience must be submitted to when they are only such as an incident to a reasonable use under impartial regulations. When the highway is not restricted, it is dedication of some particular mode of use. If that is open to the situation methods and cannot be assumed that these will be the same from age to age, or that new means a making way useful must be executed merely because their introduction may trend to be inconvenience or even to injury of those who continue to use road after the same manner as formerly a highway established for the general benefit of passage and traffic, must admit the new methods of use, whether it's found that the general benefits requires them and the law should prelude the adoption of the use of the methods. It would defeat in greater or less degree the purpose for which highway are established.
Okay, I am looking at that case. The first thing I would let you know is, do you know what the Grand Rapids GH and MR Company is?
A railroad.
Right, it's a railroad. So this is a case from 1922, 103 years ago-ish, and it's a case where the Michigan Supreme Court was essentially ruling about rules and regulations on a rail that's on, like a streetcar, essentially, a rail that's over a highway in an easement. It has nothing to do with a person traveling in a sedan in 2025 on a public roadway. I understand your argument. Do you have any other kind of cases that you think actually apply to this situation?
Yes, here's another one. Each citizen has the absolute right to choose for himself mode and conveyance.
This is one of the most instructional moments of the hearing. The judge walks through the statute clearly and methodically, explaining that Michigan's motor vehicle code applies to any motor vehicle operated on a public roadway regardless of purpose. Transportation, entertainment, errands, none of it matters. What matters is operation. This explanation dismantles the right to travel argument piece by piece without emotion. The court isn't attacking the defendant's beliefs, it's grounding the ruling in black-letter law. This is how courts neutralize misinformation, not by debate but by statute.
He desires, whether it be wagon or carriage.
I understand.
Horse,
So
motor.
I'm not trying to be rude. I might be succeeding. I'm trying to be more efficient. I think your argument is, please correct me if I'm wrong, that somehow the requirement that you have a registration plate on your vehicle is an impediment to the constitutional right to travel. Is that correct?
No.
Okay, what are you telling me then?
Ordinary use on a public road. Nothing
What about
commercial.
I didn't say anything about commercial.
No,
I
was
said,
just
are
saying
you
no.
are you trying to tell me that the law that requires you to have a registration plate is illegal because there is a constitutional right to travel?
Yes. No.
What-
No.
right. Okay, what are you telling me then?
Ordinary use of the public road.
Right. What about ordinary use of the public road?
A fundamental right.
The right to travel. I'm familiar with the
Yeah.
argument. It's been made by others. You're not the first and probably not the last to make that argument. I have ruled before, and I would rule
Yeah.
again.
Yeah.
The idea behind the thought that it's unconstitutional to require somebody to have a license plate on their car or to have insurance or something like that is an unconstitutional violation of the right to travel is simply not true. The Michigan Court of Appeals has decided that, and frankly, that's a misapplication of the phrase right to travel, because of course there's nothing that requires you to travel by personal motor vehicle and choose to do so voluntarily. And then if you do so, Michigan requires that you have insurance. It requires that you have a non-expired registration plate. You could still travel to Ohio or any place else you want. You could do it by foot. You could do it by train. You could do it by bus. You could ride in somebody else's car, right? But the idea is
not the right
there
to
is
travel,
no
then.
right. It's the requirement that you have a registration plate and that it be current does not run afoul of the U.S. Constitution's right to freely travel. Now, is there any other argument you want to make about your motion?
It's just the right to use the public highway. Not to
We all
travel,
have the right to
please.
use it, and the right to the right of the government in Michigan to say you can use this public highway only if you have an operator's license, you have a valid registration plate, and you have a minimum amount of insurance does not run afoul of the Constitution.
Yeah, that's not what I see the law says. That's why.
I understand we may disagree, but frankly, the
Yeah.
court interprets the law, and that's why I'm here. So I'm going to deny your motion to dismiss. Do you still wish to have a hearing on the case, or are you willing to admit that, on that day you did not have you had an expired registration plate on the vehicle?
No, I guess I'll have to go to court.
This is the turning point where the legal argument fully collapses. The judge explains that the cited Supreme Court case involved railroad tracks running through public streets, not private individuals driving personal vehicles. The distinction matters. Precedent must be analogous to be persuasive. By pointing out that the case has nothing to do with sedans, license plates, or modern traffic enforcement, the judge exposes the mismatch between the argument and reality. This isn't about disrespecting history, it's about relevance. Courts don't apply old cases just because they're old, they apply them because they fit.
Well, here's how this works. It's an informal hearing, so what I'll do is I'll put both of you under oath. The plaintiff in the case, which is the City of Marshall, represented by Officer Dickinson, has the burden of proof. The burden of proof in a case like this is called by a preponderance of evidence. After I put you both under oath, Officer Dickinson, who has the burden of proof, will present her case first. There aren't any rules of evidence that we have to worry about. There is one rule about the presentation, and that is that the court can consider only evidence which is relevant. After Officer Dickinson presents her case, Mr. Cousino, you're going to
Yes, you got it.
present your
Perfect.
case. Finally,
Yeah.
you get to present your case. Again, you can produce anything into evidence that's relevant. And after both sides have
Okay.
presented their cases, I'll render a decision. Either side can appeal that decision within 7 days. Mr. Cousino, if you were to appeal the decision, then you would have to put up the fines, costs, and fees as a bond pending appeal. Do you understand the process at this point?
Yes.
Okay. Can you both raise your right hands, please? Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Officer Dickinson
I do.
and Mr. Cousino.
I do. I do.
Very good. Officer, if you would begin, please.
Around 7:57 a.m. on 4/25, I observed Mr. Cousineau traveling on West Michigan Avenue with a green expiration date of July 2024 on his license plate. When I stopped him, he explained that it was in storage and that he didn't have the current registration and that somehow it got missed because he was moving because Ford was buying his house down in Michigan Ave. I explained to him that I had Lean in my computer, which is a law enforcement information network, and it's connected to the Secretary of State and updated as current as their system is, and they confirmed that his registration was expired, so I wrote him a citation under the Michigan Motor Vehicle Code 257.255 for expired registration.
All right. Anything further you want me to consider at this point, Officer Dickinson?
Nope.
Look at you.
All right. Mr. Cousineau? Is there
I'd
anything?
like to know where I didn't have a green sticker, I don't think, on my car. It's a military plate.
Okay. Anything else you want to say?
That's all I have to say, really. Except
Okay.
that, you know,
Officer Dickinson, I guess I don't know what color the plate stickers were or anything else. Do you have a recollection about whether this was a military plate or not?
I'm looking at my body cam right now. He does have a Army plate, possibly.
Is it a state of
So it
Michigan
does
sort of
look a little-
commemorative plate that says that
Yes,
has the
with
like,
the
US
Army
Army symbol?
decal on the right-hand side. So you're right. He had no sticker that I'm seeing at all. So I must have got the July 2024 date from the computer where it says the date that it expired. I'm mistaken. I did not see a green sticker. I'm sorry.
Sorry, Mr. Cousineau, are you the registered owner of the vehicle?
yes,
Okay. And I take it your birthday is in July?
yeah.
Okay. Anything else you want me to consider, Mr. Cousineau?
Here, the judge addresses the argument head-on and explains something many people misunderstand. The constitutional right to travel protects movement between states, not the unrestricted use of a personal motor vehicle without regulation. The judge carefully outlines alternatives: walking, public transit, trains, rides from others. Driving is voluntary, and when someone chooses to drive, they agree to regulation. This explanation is legally sound and appellate-proof. The judge isn't limiting rights, she's defining their scope. This moment reframes the entire debate from ideology to choice.
Just consider that I had an appointment to get everything, and you know, I just got it out of storage. Isn't
Okay.
there a leeway in that?
No, but I will consider it. It doesn't change whether you're responsible for the civil infraction or not, but I understand why you want to say that, and I understand that predicament. Anything else, Officer Dickinson?
No.
All right. Well, I've listened very carefully to the testimony, and it's pretty much undisputed that the defendant was operating a motor vehicle on West Michigan Avenue back on April 25th of 2025, and from both parties, but the officer had testified that she noticed that plate had been expired. She checked the law enforcement information network. It indicated it was expired, and Mr. Cousineau has testified here today that it was a military plate. He had gotten it out of storage, and he had an appointment in the future for the Secretary of State so he could make that plate be essentially not expired. Given those facts and those circumstances, I do find you responsible. It cost you $700 to get that?
Yeah, $700 and some dollars.
All right.
It was over
And you-
700.
And you went and paid it?
Yes, yeah, I paid it when my appointment was up.
Well, in light of that, I do find you responsible, but instead of assessing $110, what I'll do is assess $90 because I think the Secretary of State penalized you quite a bit financially.
Yes.
But I do obviously have to enforce the law as it's written. So what I'm going to do is indicate that I'm finding you responsible. You'll have to pay $90. Total fines, costs, and fees. Can you have that paid by July 15th, or do you need more time?
Yeah. I
Okay.
got to get to Battle Creek. I moved now, so I'm
Well,
ways
you can,
away.
I believe they have a way you can pay it online now, or you can pay it in the mail. If you use a credit card, yeah, if you use a credit card, they'll add a credit card fee. But do you want me to give you till the end of July? Will that help?
Yes. Can they send a check to them, a personal check, or no?
Yeah, you can. Basically, when you get a copy of the judgment, if you have any questions about how to pay it, you can call the district court clerk's office, which is the same number you called originally to say you wanted an informal hearing. Does that make sense?
Okay. Yes. Do you have my right address now?
Well, I don't know. That's the next thing I was going to ask.
It's
The notice that we
9009 McCain Road.
I don't think I have that. So hold on. Before we let you go here. All right. What's 9?
9009 McCain Road.
MC
Parma.
MCCAIN
MCC. Yes.
Road, Parma, Michigan.
49269.
4926. I'm going to say it one more time out loud. Well, it is 9009 McCain Road, Parma, Michigan 49269. Is that correct?
Yes.
All right. Basically, what's going to happen is I'll draw up a judgment. It'll go out in the mail tomorrow. It'll take a few days to get to you. Just make sure you have it paid off by July 31st, okay?
Okay, thank you.
This case highlights the difference between belief and burden. The defendant focused on theories about travel rights and commercial activity, but the court focused on statutory application and evidence. The judge carefully explained the law, rejected inapplicable precedent, and applied a low evidentiary standard appropriate for civil infractions. Importantly, the court still exercised discretion by reducing the fine, separating enforcement from punishment. Compliance after the fact mitigated the outcome, but it didn't erase responsibility. The final ruling reinforces a simple truth: courts don't debate internet theories, they apply written law. Backhand index pointing right. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.